Yes, sir.
All right. Now I'm going to hold this document up to you. That's a 3-page document. The first page has the plea of guilty form. Says you're pleading guilty to 2 amended counts, 1 and 3. And I'm going to hold it up there and ask you if you recognize that.
Yes, sir.
All right. On page 3, there is a sentence about a third of the way down the page. Reads, "I enter this plea voluntarily." It looks like below that is a signature, Sam Baumgartner. I'll hold that up and ask you if that is your signature there.
Yes, sir.
When did you sign this agreement, Mr. Baumgartner?
About a week ago.
And when you signed it, did you understand it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case will be a sentencing hearing?
Yes, sir.
And is this something that you had discussed with your attorney and gone over with before you signed it?
Yes, sir.
And do you feel you had enough time to fully consider the matter before making this decision?
Yes, sir.
And it's been a week or so ago since you signed it. Is this still what you want to do?
Yes.
And did you enter this agreement? Are you going forward with this agreement voluntarily?
Yes, sir.
All right, now the agreement states on page 1 that you're going to plead guilty to counts 1 and 3 as amended. Currently, count 1 is aggravated trafficking in the vicinity of a school zone, a second-degree felony, and count 3 is aggravated trafficking in methamphetamine, also a second-degree felony. Now, the second-degree felonies then carry mandatory prison term of at least 2 years, up to 8 as ordered by the judge, with the possibility of that being extended by an additional 1/2 by the Department of Corrections. A third-degree felony, which is what these are being amended to, would reduce that. And it says here on page 1 that you understand that that is a possible prison term of a minimum of 9 months up to 36 months in each count, a fine of up to $10,000 on each count, mandatory fine of $5,000 each count, a possible license suspension of 6 months to 5 years. Do you understand that?
Yes, sir.
Now, under the law, those are not mandatory prison terms. That's a big difference between the second-degree felony, plus it lowers the possible length of your sentence. However, those sentences could be ordered to be served consecutively to each other, meaning one after the other. So if you receive the most serious penalty available of 36 months on each count, that means that could be a total of 72 months as a maximum. You understand that?
Yes, sir.
Other than these 2 charges, Mr. Baumgartner, are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently on community control, parole, post-release control, or probation from any jurisdiction?
No, sir.
Now, under the law, if you are convicted of these offenses and sentenced to prison, once you complete that prison term, the Adult Parole Authority does have the authority under the sentencing law, if they choose to exercise it, to extend your, or to put you under post-release control for a period of up to 2 years. And that means you'll be supervised by a parole officer on the terms they set. If during that period of time they determine that you have not complied, they could return you to prison and make you serve an additional period of up to 9 months for a single violation, but there is a cap or limit of half of your prison term for all violations. However, if your violation is a new felony, then in addition, whatever sentence a judge in the new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence of the new case. Do you understand that?
Yes, sir.
Now, under the law, these sentences are not mandatory. There's a presumption you should be sentenced to prison, but it's not mandated. And so I could decide, rather than sentencing you to prison, to put you under what's called post-release control for a period of up to 5 years on a term set by the court, which means you'd be supervised by a probation officer under those terms. And if they felt that you were not compliant, they would have to file a written notice of that with the court, give you a copy, there would be a hearing, you'd be entitled to have an attorney. The outcome of that hearing was that you'd failed to comply, then at that time, the court could revoke your community control and then sentence you to prison for 72 months and fine you $20,000. You understand that?
Yes, sir.
All right, now, currently count 1 reads as on or about July 1, 2022 in Highland County, Ohio, you did sell or offer to sell methamphetamine, Schedule 2 controlled substance, an amount equal to or exceeding bulk amount but less than 5 times bulk amount in the vicinity of the school zone. And so to get it from a second degree to a third degree, Mr. King, I assume that the state is moving to delete the vicinity of the school zone.
Yes, sir, Your Honor.
Okay. And in count 3, alleges on or about July 22, 2022, in Highland County, Ohio, Mr. Bumgarner, that you sold or offered to sell methamphetamine and Schedule II controlled substance amount equal to or exceeding 5 times bulk amount but less than 50 times bulk amount. That's a second degree felony. To get that to a third degree felony, as states amending that to reduce the amount involved to be over bulk but less than 5 times bulk. Is that correct?
Correct, Your Honor.
All right. So that's how you get to the third degree felonies then with those amendments. Now, Mr. Bumgarner, with that amendment, do you understand in each case what it is, or each count, what you've been charged with, what the state said you did, when, where, and how you allege that you did it?
Yes, sir.
You discussed the nature of that charge, or those charges, the evidence of the case, the possible legal issues of the case, the possible defense you might try to raise at trial, and the possible outcomes of a trial with your attorney.
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty?
No, sir.
Now, on page 2, there are several lines printed in bold and underlined that I'll read as follows. Defendant will enter a plea of guilty to count 1 as amended and count 3 as amended. State will dismiss remaining counts. State and defense jointly recommend 24 months incarceration on count 1, consecutive 24 months incarceration on count 3. State will not oppose judicial release to substance abuse treatment after 6 months incarceration. Defendant agrees to cooperate fully with the task force. Defendant agrees to repay by money to the task force in the amount of $1,170. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty?
No, sir.
Under the law, Mr. Bumgarner, the matter of sentence is up to the judge, not the parties, and so even though there's an agreement as to what the sentence should be, if you plead guilty to these 2 charges, I'm not required to follow that agreement. I could give you any sentence between 9 and 36 months that I think are appropriate. And if you do get sentenced to prison, I'm not obligated to grant judicial release just because the state's not opposed. Do you understand that?
Yes, sir.
Now, do you hold any kind of a license or certification from any state governmental agency that regulates any occupation or profession?
Like a photo ID?
No, I mean like, are you hold a vet tech, a pharmacy tech, an STNA or something like that, a teacher's aide or anything like that?
No, sir.
Okay. Now you have certain constitutional rights you must understand before it can accept a plea from you. First, you have right to counsel, and Mr. Wagner was appointed to represent you. Now that wasn't simply to work the case out, but to provide any defense that may be available to you under the law that you like him to provide. So if you decide that you do not want to plead guilty, that you want to defend against this case, he will continue to represent you, including a trial if that's what you want. Do you understand that?
Yes, sir.
Right, under the Constitution, you have right to have a jury trial on this matter in which 12 people would be selected from a group of citizens that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented. The judge will instruct that jury on the law. And then they would decide by unanimous verdict, meaning all 12 would have to agree, on whether the state proves your guilt. Now, if you decided you did not, and that would happen as to each count. Now, if you decided that you didn't want to have a jury trial, but you didn't want to plead guilty, then you can waive in writing, which means you give up the right to have a jury trial, and in that case you would have what's called a court or bench trial, meaning the judge would be the one who would hear the evidence to tell the jury, the judge would apply the law, the judge would decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to confront witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have the right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order, which is a subpoena, which forces those people to come into court to testify if you want them to, even though they don't want to be here. And that's the same way the state's witnesses are required to come into court to testify against you. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination. which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you do not testify, then the judge does instruct the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
All right, now, under the Constitution, you are presumed innocent of these charges until proven guilty by the state on every essential element of the offense charged. What that means is that the burden of proof isn't upon you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you're not required to put on any evidence at all at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and exercised and revoked all the rights that I've just described. If you change your plea from not guilty to guilty to these two charges as amended, then that is the opposite of the not guilty plea. It admits the allegation in the indictment, admits that there is a crime, that you committed that crime. And that plea waives, gives up all the rights that I've just described for you, except the right to have an attorney. You always have a right to have an attorney no matter what your plea, but with that exception, your plea of guilty waives, gives up the right to a jury or court trial. Waives, gives up your right to confront witnesses against you and cross-examine through your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses being in court to testify for you, the same as the state. It waives, gives up your privilege against self-incrimination because if you say you're guilty, the state's not required to prove you're guilty. It waives, gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being immediately sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if you are sentenced to the maximum sentence under certain circumstances, you could file an appeal. That appeal will have to be filed within 30 days of your sentencing entry being filed. Do you understand that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Right now, Mr. Bumgarner, you have any questions about the two charges as amended or the penalties for those?
No, sir.
You understand them?
Yes, sir.
Have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
And again, you understand the recommendation on sentencing and the recommendations on judicial release are not binding on the court,
Yes, sir.
right? Do you have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
Have any questions about the plea of guilty, what it means, and what will happen if you enter that plea here today?
No, sir.
You understand it?
Yes, sir.
I didn't say this to you at the beginning, but if you need to talk to Mr. Wagner, I can put the two of you into a breakout room, and you can talk to him privately. No one else will be on the screen except the two of you, and the deputy would step out during that conversation, so it would be totally private. Do you need to do that for any reason?
No, sir.
Have any questions about anything I've explained?
No, sir.
Then is it your decision to withdraw your not guilty plea and plead guilty to the two amended charges in counts 1 and 3 pursuant to the terms of this plea agreement that we've just gone through?
Yes, sir.
All right, then as to the amended charge in count 1, and the court will make those amendments here to the document in ink. So the amendment would read that on or about July 1, 2022 in Highland County, Ohio, Samuel Adam Bumgarner did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance, amount equal to or exceeding bulk amount but less than 5 times bulk, in violation of Section 2925.03A1, charge of aggravated trafficking of methamphetamine, a third-degree felony, carrying the penalties described in the plea agreement of between 9 and 36 months, increments provided by law, fine of $10,000, mandatory fine of $5,000, and possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, then as to the count 3, which is amended, would read the same, except it would be July 1, 2022, otherwise the same offense and the same penalty. How do you plead?
Guilty.
All right. The court finds that on this day, an open court defendant was advised of all of his constitutional rights and made a knowing, intelligent, voluntary waiver pursuant to Criminal Rule 11. The plea is accepted and order filed. Defendant is found guilty of both counts 1 and 3 as amended, third-degree felonies. and counts 2 and 4 are dismissed. Now, the court finds that there's an agreement as to sentencing, and based upon the nature of the offenses, the court is not going to order a pre-sentence report, so we'll go ahead and proceed with sentencing. Anything from the state?
Only motion to take the plea agreement, Your Honor.
Mr. Wagner?
Likewise, Your Honor, we would ask the court to follow the recommendation of the parties. We will file the appropriate judicial release and have to review that in 6 months.
Bumgarner, anything you'd like to say? Got your jail time credit, then. All right, then it's the order and judgment of the court that you be and are hereby sentenced on each of the 2 counts to a term of 24 months in the Correctional Reception Center at Orion, Ohio. Those sentences are ordered to be served consecutively to one another. The court finds that the consecutive sentences are appropriate. The parties have agreed to that, plus the offenses committed part of one or more series of conduct, and that one single punishment would not accurately reflect the seriousness of the offense, and that the harm caused, and the amount of the sentence is not disproportionate to the harm caused, and plus the defendant's criminal history warrants that the sentences be served consecutively for the protection of the public. The defendant's granted 40 days of jail time credit, according to the sheriff. You were arrested originally, it looks like, on, was it June, let's see, when were you arrested?
August 24th.
Oh, here we go, August 24th, okay. All right. So that is a total of 40 days. No, that's not, that's right. This was printed on October the 2nd. So today is October the 12th. So that would be 10 more days. So well, actually, that's not correct. August the 24th, 7 days in August, 30 September is 37, and today is the 12th, so that is 39 days. All right, or 49 days, I'm sorry. So 49 days of jail time credit. Now, upon completion of this prison term, Mr. Bumgarner, it is possible that the Adult Parole Authority may put you under post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised on the terms that they set by a parole officer, and if during that period of time they determine that you have failed to comply, they can return you to prison, make you serve an additional period of up to 9 months for a single violation, up to 1/2 of your sentence for all violations, which would be 24 months. However, if you commit a new felony, then in addition, whatever sentence a judge in a new case can impose upon you, that judge could also sentence you for committing that offense under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in a new case. You're also ordered to pay $1,170 in restitution to the Huntington County Task Force, payable through the Huntington County Victim Witness Restitution Office account. You're also ordered to pay the court cost, and if you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court could order you to do community service once you get out of prison, not while you're in prison, but once you get out in this county, and give you credit for each hour you worked at an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Has there been any change in your financial status since I appointed counsel for you?
No, sir.
All right, then the court will find that the defendant does not have the means to pay the mandatory fine, nor is he likely to have it in the near future, so that will be waived. Anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, you're remanded back to custody. All right, are you Charles David Howland appearing there from the jail?
Yes, sir.
All right, there are two cases before the court involving Mr. Howland. Case number 23 CR 168 and 23 CR 172. He is charged in 168 with one count of aggravated possession of a fentanyl-related compound, a fifth-degree felony. 172, he is charged along with 2, 4, 6 co-defendants. In a multi-count indictment, he is charged in counts 20 through 30 with various felony drug offenses, fourth and fifth-degree felonies. Mr. Howland's attorney is Jeffrey Blosser, appearing by Zoom from his office, and appearing from the prosecutor's office by Zoom is Adam King, assistant prosecutor. Now, I think this is the final pretrial. The trial is actually set for November the 9th. I see that the state's provided discovery. Did you provide your discovery yet, Mr. Blosser?
Your Honor, on case 23 CR 168, I filed the response on the September 26th. At the same time, my file shows that I also sent the 23 CR 172 response. That was in my file, but when I looked at the clerk's website earlier, I didn't see that that was actually filed, so I refaxed that today.
Okay.
Whether or not the prosecutor's office received it, I'll confirm it to them separately. They may have gotten it back in 1926.
We did, Mr. Blosser.
Okay.
Okay.
All right, good. All
I
right.
don't know anything, so I'm sorry.
So discovery would be complete then?
It is.
All right. Now, there are no pretrial motions?
No, sir.
All right. Now, where do we stand regarding these two cases?
Your Honor, an offer was conveyed to Mr. Howland on Monday, October 9th at the jail. He had a couple of questions that he wanted me to address with the state. I've been in trial the last 2 days. I plan to do so, but I believe we're heading towards resolution, and we probably should get that scheduled fairly quickly.
Okay. All right. Well, if that happens, then we'll need to do that.
Yes,
So, because the matter is coming up on November the 9th, and my calendar is pretty full this month.
Your Honor,
Yeah. Yes?
did I say something?
About what?
I'm ready to proceed today, before it is.
Okay, well, there's more to it than that. We need to have paperwork and so forth, so your attorney is going to get back with you, so hopefully,
I'll be over Sunday.
yeah, he'll said he'll be there to see you Sunday then.
Okay.
All right, thank you.
Thank you.
All right, are you Christina Cassidy appearing there from the jail? Yes. All right. This is case number 23 CR 156, State of Ohio versus Christina Cassidy. This is a final pretrial being conducted by Zoom. She's appearing from the jail. Appearing on behalf of the state is Assistant Prosecutor King. Defendant's represented by William Armentrout, who's appearing from his office. Defendant's charged with 2 counts of aggravated vehicular assault, operating a vehicle under the influence, and grand theft of a motor vehicle. I believe this is a final pretrial. We have a trial date set for November the 6th. Now, I believe that the state provided discovery. I don't see your discovery, Mr. Armentrout.
You have mine, Adam? You know?
Hang on. No, I did not believe so, Mr. Armentrout.
Okay.
File it right after this hearing, Your Honor. There's nothing unusual in it, I can tell you that.
Okay. You, and I don't see any pretrial motions either, is that correct?
No, that's correct.
All right. And where do we stand on this case then?
Your Honor, I had further negotiations just a while ago this morning with Ms. Collins over a couple issues and some of the evidence. I believe we're proceeding toward a resolution. I would probably be contacting your assignment commissioner to schedule this prior to the 14th day.
Okay. All right, any other matters need to be discussed?
No, Your Honor.
There you go.
All right, thank you. All right, this is case number 23 CR 169, State of Ohio versus Austin James Taylor. And are you Austin James Taylor appearing there from the jail?
Yes, sir.
All right. This is a pre-trial. Mr. Taylor is represented by Jacob Wagner, who's appearing by Zoom from his office, appearing from the prosecutor's office, Assistant Prosecutor King. And Mr. King, has the alleged victim of this offense been notified of the time, place, and purpose of this hearing, the right to be present, to be heard?
Yes, sir, for the alleged victim mother is monitoring this hearing on the screen bar. Tiffany's item.
All right, thank you. All right, defendant's charged with 2 counts of rape and 1 count of gross sexual imposition. This matter is set for trial on November the 6th. I see that the state did provide discovery. Looks like Mr. Wagner, you filed your discovery as well. Is the discovery complete then for both sides?
It is for the state, Your Honor.
At this point, yes, sir.
And I don't see any pretrial motions. Have you filed any motions?
Your Honor, I've analyzed the file backwards and forwards, and at this point, I don't see any motions from the defense counsel.
All right. And what's the status regarding the written plea offer?
Your Honor, if I may, I've been out to see my client several times now, recently just today prior to the hearing. Your Honor, he's aware of the offer. His arraignment was less than 30 days ago, Your Honor. Due to the fact that these are 2 F1s, my client's in agreement if the court would be inclined to allow us to waive time, grant us 1 reasonable continuance in this matter, Your Honor.
All right, Mr. King?
The state has no objection, Your Honor. The state has consulted with the victim representative also. There's no objection.
All right. Mr. Taylor, what's going on then is you're right now set for trial on November the 6th, which is about 3.5 weeks away. But right now, you're set for trial November the 6th. Now, if I continue this at your request, that means that you have to agree that you're going to waive any speedy trial rights and agree to this case to be continued and that speedy trial time to be extended. You understand that?
Do you understand that, Austin?
You understand that, Mr. Taylor? All right. All right. And are you in agreement then with waiving your speedy trial rights and having this case continued?
Yes, Your Honor.
All right. Court then will find the defendant has waived his speedy trial rights and will continue the case at the request of the defendant, and that extends the speedy trial time pursuant to RC 2945.72H. I will set a new trial date for, let's see, December the 4th. At 8 a.m. And we'll set a final pretrial for November 15 at 1 p.m.
Thanks, sir.
All right, is there anything further from counsel?
No, Your Honor.
All right, thank you.
Can you hear me, Your Honor?
Yes.
I spoke with a gentleman named Vic Gall. I believe you might know Vic Gall. It's
Yes.
her fiance. He is back confirmed today. She's at Highland District Hospital as we speak, awaiting transport to Cincinnati for, I believe, at least 1 stent.
Ms. James is?
Yes, sir.
So she's not in jail?
No.
Oh, okay. Oh, okay, I thought I had her down as being in jail. Okay, I'm sorry. Well, we'll go ahead and call the case then. Case number 23 CR 162, State of Ohio versus Shannon Renee James. This is a pretrial being conducted by Zoom. Her attorney is William Armentrout, and appearing from his office and appearing on behalf of the defendant, or the state, is Assistant Prosecutor King. All right, now, Mr. Armentrout, I don't think we may not have been on the record, so if you would just state again what you just indicated.
I spoke to a gentleman named Vic Gall. I believe the court's familiar with Vic. I've known him. They are, Ms. James is his fiance. He was in contact with my office today that she is at Highland District Hospital, awaiting transport, I believe, to Cincinnati, but she needs at least one stent put in. This is the first pretrial. The state has made an offer, which I think probably resolves the case, although she's been ill. I haven't had a chance to communicate that with her.
Okay.
If everything goes smooth, I would assume that at or before the final pretrial, we can resolve this matter.
All right. Well, since she's in the hospital today, the court will obviously excuse her appearance, and we'll go ahead and just leave it on the docket for right now. The final pretrial is the 15th of November. If something is going on with her health that needs to be continued, certainly I would understand that. So as long as you have the documentation, we can deal with it that, or hopefully she'll make a speedy recovery and be able to do something pretty quickly. But we can deal with any further delay might be necessary due to this situation at that time. All right, anything further from counsel?
No, Your Honor. Thank you.
Wald? Case number 23 CR 126, State of Ohio versus Trenton Zumwald. Mr. Zumwald, you need to unmute yourself there. You're on the screen. I had to mute you earlier because there was some background noise coming over your mic. All right. You are Trenton Zumwald, appearing on the screen marks. Trenton Zumwald.
Yes, sir.
All right. And this is case number 23 CR 126, State of Ohio versus Trenton Andrew Zumwald. So final pretrial being conducted by Zoom. Mr. Zumwald is appearing. Are you in your vehicle?
I am.
Okay. On his phone, and his attorney, Danielle Witt, is appearing from her office, and appearing from the prosecutor's office, Assistant Prosecutor King. Defendant is charged with one count of having a weapon under disability. This is a final pretrial. See, state provided discovery and bill particulars. I don't see your discovery, Miss Witt. Did you provide your discovery?
I did just a little bit ago, so it probably hasn't gone in.
Okay. So discovery is complete?
Yes, it is.
And you didn't file any pretrial motions, did you?
No, no pretrial motions, and there was no additional discovery.
All right. All right. So how do we, or where do we stand regarding the case?
If I could have more time, Your Honor, to discuss the case with Trenton, and then also possible further resolution, I feel like we could continue this till early next week. That would be helpful.
Well, I'll be out next week, but we can go ahead and continue the matter if you want to. I think we can set it for the 27th. I also am having to do some hearings in Columbus on the 3rd, on the 23rd, 4th, and 5th. So I believe the 27th would be a date that we could do. Well, that's Friday, though. I think that might be drug court. I think we're doing them on the 26th. So you want to set this down for the 26th at, say, 10 a.m.?
Yes, please.
All right. And we will continue it till then. Now, and Mr. Zumwald, are you in treatment?
I am.
Where are you?
It's United Family Recovery in Ironton, Ohio.
Okay. So you're out working? Is that why you're not at the facility right now? Okay.
Yes.
Right, okay. All right. Well, then we'll do that by Zoom, and we'll set it for the 10 a.m. I may have to tweak that a little bit because I didn't check with my assignment commissioner. I know that date's pretty full because that's going to be the first date I'm available to do a lot of things because of my schedule with things in Columbus. So if you would get a hold of the I'll have the assignment commissioner confirm that and send you a notice. And Mr. Zumwald, make sure you talk with your attorney so we can see if this matter is going to be resolved. Okay, thank you.
Thank you.
Right, this is case number 21CV185, Highland County General Health Department versus Susan Hatfield, Health District versus Susan Hatfield. Plaintiff's represented by Assistant Prosecutor King. Mr. Webb is appearing on behalf of the department. And you are Susan Hatfield?
Yes.
All right, this is a purge hearing. The defendant was found to be in contempt of court by entry filed on August the 15th, at which time the court sentenced the defendant to serve 60 days in the jail and allowed her an opportunity to purge herself in contempt by cleaning the debris up, and the matter was set today for hearing. What's the position of the plaintiff regarding the purge, Mr. King?
Your Honor, the defendant has made progress. She was last in court in August. It has been cleaned up some, but there's still some work to be done.
Ms. Hatfield, what's going on? Why haven't you got it cleaned up?
Well, I've been working and doing the yard, and then I had to take my husband to the hospital because his sugar went up to 700, but most of it's all done besides a little bit.
What do you describe as a little bit?
We still got to weed eat a little bit out back and.
Well, weed eating is not the issue. It's
And
garbage and trash. And
he's already got a load to take into he took it in today, and he's got another load to come back to take in to the junkyard. Because we used the trailer to do the trash yesterday and everything.
how much more time do you think it'll take for you to get this done? Because you got 60 days looking at you if you don't get it done.
For me,
I said, how much more time do you think you need to get this done? Because if you don't get it done, you're going to do 60 days.
I said within a week or two, it should be all completely done.
All right? Have you been talking with Mr. Webb about this? You've been in communication. Have you talked with her at all about it? All right, so she knows what she's got to do to get
Yeah,
done.
he was out the
All right.
house this morning.
Okay. November. All right, I'm going to continue this hearing to November the 3rd at 10:30 a.m. If it's cleaned up and the plaintiff notifies you and the court that it is cleaned up, then you will not have to appear. But if they don't, you'll need to appear, and I can tell you, I'm running out of patience. You know, we did this last year, same time, same place. And then here we are again. And back in August, they gave you 60 days, and, you know, we're here, and you're not cleaned up. And so that's going to be your last chance, okay? Because I've had 2 people out there at the lake that have served time for jail for not cleaning the properties up, both of them women, coincidentally. Not that that has anything to do with it, but don't think for a minute that you're not going to do the time if you don't clean it up. All right? Thank you.